You are listening to the global network of podcasters dedicated to the pharmacy profession. Welcome to the Pharmacy Podcast Network.
You're listening to the NASP Specialty Pharmacy Podcast, a collaboration between the National Association of Specialty Pharmacy and the Pharmacy Podcast Network. Each episode dives deep into trends, challenges, innovations, and patient-centric practices shaping the future of this dynamic and rapidly evolving industry. Whether you're a pharmacist or healthcare provider, patient advocate, or industry leader, you'll hear expert insights, real-world evidence, and thought-provoking discussion that highlights all that makes specialty pharmacy special.
In support of NASP's mission to empower specialty pharmacy stakeholders to advance the standard of patient care, NASP supports a free market healthcare system in which all specialty pharmacies compete on the same fair and level playing field, because that is in the best interest of the patients we collectively serve. NASP is committed to working with all stakeholders and policymakers to ensure that all patients have access to the life-saving medications they need and the high-touch patient care and support services they deserve from the pharmacy of their choosing.
Hello, my name is Sheila Arquette, and I am the President and CEO of the National Association of Specialty Pharmacy. I am delighted to welcome two very special guests, Jonathan L. Swichar and Bradley A. Wasser, to this episode of the NASP podcast. Jonathan Swichar is chair of the Duane Morris Pharmacy Litigation Group and a member of the firm's Governing Partners Board. For more than 25 years, Mr. Swichar has represented thousands of independent pharmacies and healthcare providers in regulatory, civil, and criminal proceedings. His practice is dedicated to representing all provider types throughout the U.S., including specialty pharmacies, mail-order pharmacies, retail pharmacies, compounding pharmacies, home infusion pharmacies, telehealth pharmacies, hospital pharmacies, home care pharmacies, long-term care pharmacies, oncology pharmacies, among others. He has handled thousands of matters on behalf of such providers involving all aspects of their business operations, including but not limited to issues with payers and pharmacy benefit managers, PBM audit appeals, challenges to network terminations, refusals to provide network access, and in the submission of credentialing applications. Bradley A. Wasser focuses his practice on litigation, regulatory compliance, and government advocacy, with a nationally recognized concentration in pharmacy law and disputes involving pharmacy benefit managers. He provides strategic legal, regulatory, and business counsel to pharmacies, healthcare providers, and national healthcare associations, as well as clients in other regulated industries. As a member of Duane Morris's Pharmacy Litigation Group, Mr. Wasser has developed deep experience representing pharmacies of all types: retail, mail order, infusion, institutional, and specialty, in high-stakes matters involving PBMs and insurance companies. His work spans disputes over network participation rights, provider terminations, audits, reimbursement rates, and contractual negotiations. The information, thoughts, and opinions expressed today belong solely to the speakers and do not necessarily reflect those of NASP. Jonathan and Brad, thanks so much for joining me today.
Sheila, this is Jonathan. Thank you very much for that introduction, and we very much appreciate the opportunity to participate in today's podcast.
The 2026 Consolidated Appropriations Act is being described as one of the most significant federal PBM reform packages to date. What events do you think motivated the passage of the act, Jonathan?
Sheila, it's a good question, and I think to understand what led to PBM reform in the Consolidated Appropriations Act of 2026, it would be helpful for your listeners for me to provide a summary of the events that led to the passage of the Act. Rarely in the practice of law is there a timeline leading to the passage of a law that involves so many years and so many factors. While for much of society, the Act might be the first time they're learning about PBMs and the plights of independent specialty pharmacies, which for purposes of today means pharmacies not affiliated with PBMs. There's an approximate 70-year history of events and developments that had to occur to summon the requisite congressional support to introduce and pass the PBM Reform Act. And being sensitive to the hour that we have for this podcast, let me try to summarize as succinctly as possible how 70 years or so of grassroots efforts by independent specialty pharmacies, rules implemented by CMS, laws passed among various states and government agency investigations in combination drove the passage of the act. The first approximate 30 years of the 70 years in which PBMs have existed, pretty easily summarized. As you and most of your listeners are likely aware, PBMs developed in the 1960s. Their original role was relatively mundane and non-controversial. They were simply paid a fee to assist insurance companies in processing claims by pharmacies for their drug plans. It was a series of really mundane administrative tasks. In the 1970s and 80s, however, certain PBMs sought out additional sources of revenue, and they began to offer insurance companies additional services, such as developing networks of pharmacies, developing formularies that pharmacies had to follow, and setting reimbursement rates for prescriptions filled by the independent pharmacies in their network. The revenue for these types of services were primarily compensated based on benchmarks as to how much the PBMs could demonstrate they were saving their insurance plan clients. This really was the origin of PBMs not viewing independent pharmacies as business partners, but often as adversaries regarding the amount of revenue that PBMs could otherwise generate. And during the 1970s, 1980s, and continuing into the 1990s, the terms and conditions that PBMs established to allow pharmacies to participate in these networks became stricter and stricter. The reimbursement rates dramatically lessened, and it became much more difficult for independent pharmacies to service their customers. And over these 3 decades, thousands of pharmacies nationally began to complain about how certain PBMs had evolved and how they were making it very difficult for them to stay in business. Now, PBMs, on the other hand, during this time period would respond quite differently. They would say that their increased scrutiny of pharmacies seeking to participate in their networks helped to eliminate pharmacies that were not best qualified or most appropriate to service their insurance company clients. They also would routinely tout that these approaches were reducing reimbursement rates, thus saving significant sums for insurance companies and allowing them to reduce the costs of their insureds. And while legislators on both the state and federal level would often be the audience for these dueling positions, during this time frame, there were no laws on either a state or federal level that empowered them to do anything about these complaints. The standard response from state and federal legislators would be, with regard to pharmacies, we feel your pain, but absent any laws on the books, there's really nothing we can do to assist. So the advice that these legislators would often provide to pharmacies or the lawyers representing them was to either seek relief in courts based upon common law or engage a lobbyist to try to convince legislators to introduce a bill which might a couple of years later receive sufficient support. Usually these complaints are coming from pharmacies at a point in time in which they think that their business is imminently at risk. They don't have the ability, either financially or otherwise, to participate in litigation or lobbying efforts. So for quite some time, these pharmacy complaints just couldn't lead to PBM reform. Now, the early 2000s is really when the landscape changed with regard to PBM reform and the way in which legislators on the state and federal level would consider the complaints from independent pharmacies. At that point, as you and your NASP members are likely aware, PBMs began to seek additional revenue, and the primary source that they turned to develop that revenue was by developing and opening affiliated pharmacies. So all the major PBMs opened either brick and mortar pharmacies or mail order pharmacies. And at that point, the PBMs who were responsible for deciding which independent pharmacies would participate in their networks and with what conditions were now in direct competition with the pharmacies owned and operated by certain of the PBMs. This led to quite a few additional complaints by independent pharmacies that they were being excluded by certain PBMs from networks. They were being terminated without cause or with cause based upon immaterial grounds. And far too often, the reimbursement that they were being forced to accept was below their wholesale costs. So as these complaints grew louder and louder, CMS became concerned about how these tactics were impacting the Medicare population. This led to what we consider to be the first truly meaningful reform on a federal level, and that was in 2003 with the passage of the Medicare Prescription Drug Improvement and Modernization Act. That was the law that required that Medicare Part D sponsors permit any pharmacy willing to accept the plan's terms and conditions to participate in the Part D network. That was pretty significant progress on a federal front, but the concern as of 2003 was the law did not require that PBMs or insurance companies otherwise act reasonably with regard to independent pharmacies. It was years later that CMS began to issue guidance that terms and conditions of Medicare Part D networks had to be reasonable and relevant. And fortunately, these principles were later codified into law. The main problem that existed thereafter, up until the passage of the PBM Reform Act, is the fact that CMS did not have enforcement authority to the extent that an independent pharmacy believed that a PBM was not complying with the reasonable and relevant obligations that CMS said PBMs were required to abide by. CMS went out of its way to make clear that Congress did not bestow upon it the ability to get in the middle of a dispute between pharmacies and PBMs as to whether a PBM was acting reasonably regarding network participation conditions, reimbursement rates, et cetera. Now, Brad will discuss shortly how that is largely being remedied by the PBM Reform Act, but let me just make a couple of other points and then I'll hand it back off to you. One thing that I assume most of your listeners are aware of, and it's important to keep in mind, is that CMS and the federal government can only regulate Medicare and ERISA plans. States, on the other hand, can only regulate commercial plans. What's interesting about the last approximate 30 years is that states have really been ahead of the curve, passing laws for the benefit of independent pharmacies. And it was actually states who, in the early to mid 1990s, were the first to pass any willing provider laws to protect independent pharmacies. And over the next approximate 20 years, once again, it was the states that took the lead in expanding the rights to independent pharmacies to go beyond any willing provider. So the grassroots efforts by independent pharmacies to reach out to state legislators has really been the initial source of certain protections for independent pharmacies. The challenges to those laws tend to go through the court system, when the courts would then affirm the legality of the laws that states were passing. It was often the federal government who would then, becoming more aware as to what was going on with independent pharmacies, pass or attempt to pass laws for the benefit of pharmacies that would impact, again, the types of plans that the federal government has the right to regulate, that is ERISA and Medicare. The last 5 years, and I'll conclude with this, we really have seen more efforts at reform, I would say more developments that led to the passage of the act than we've seen in the last approximate 70 years. It's pretty well known that since mid-2022, the FTC has been conducting a study, an investigation into PBMs. They've issued 2 interim reports, which contain very detailed findings as to the manner in which PBMs, according to the FTC, certain PBMs, according to the FTC, have acted unfairly towards independent pharmacies, such as patient steering, reimbursement rates. And the second of the 2 interim reports, I think, is of particular interest to NASP and its members because the focus was on specialty pharmacies and specialty medications. And over the course of approximately 70 pages, the FTC, in a fairly detailed manner, detailed the way in which certain PBMs were complicating business for specialty pharmacies. They noted that far too often, certain PBMs would categorize medications to be specialty medications, when in reality they were retail. They identified circumstances in which certain PBMs would require that individuals only obtain specialty medications from pharmacies in their specialty networks. Independent pharmacies far too often have extreme difficulty getting into the specialty networks that certain PBMs establish. And up until the passage of the act, PBMs would have a relatively easy time convincing insurance plan clients to require that individuals who require specialty medications only get them from the specialty pharmacies that are owned or affiliated by the PBMs. So those 2 interim reports, coupled with a groundswell of protection that has developed on a state level, coupled with some court opinions which have recognized the legality of legislators trying to benefit independent pharmacies, really is what led to what we're here to discuss today, the PBM Reform Act. So with that introduction, let me pause and we'll continue the discussion about the act.
Sure. Can I just ask a question for clarification purposes? So when we're talking about independent pharmacies, we are talking about really non-affiliated pharmacies with the PBM, right? It's not just the independent retail pharmacies. It's right, like, 'cause specialty pharmacies aren't that, but it's everybody, right?
Any pharmacy that is not affiliated with a PBM falls within my definition of an independent pharmacy. Yeah, the pharmacies that are not affiliated with the major PBMs, the ones that are not large retail chains that are known to be owned by the PBMs, these are truly independent pharmacies, whether they're specialty, retail, or other types.
Wonderful. Thank you. So which provisions do you think will have the biggest operational impact on PBMs and pharmacies over the next couple of years?
Yeah, and Sheila, this is Brad. I'm happy to take that question, and thanks for that. So, look, there are a number of provisions that impact PBMs and pharmacies that pharmacies, particularly us as pharmacy attorneys, are paying particular attention to. And look, we're going to closely monitor over the next couple of years how they're going to impact or how they will be impacting, the operations of the PBMs, the treatment by PBMs of non-affiliated pharmacies, et cetera. But there's a couple of provisions, particularly related to, those operational changes that stand out from our perspective, and I think the largest is those touching on, pharmacy network access and the any willing provider law, which Jonathan had just talked about. But let me touch on that a little bit last. Let me circle back to that because I think that's probably the biggest topic of discussion for us since it has such impact or potential to impact our clients and, as well as PBMs and other stakeholders and how they're going to be operating on a going forward basis with respect to how they're treating PBMs, how they might be designing pharmacy networks, how it impacts reimbursement rates for pharmacies, et cetera. So one particular area of interest also, and again, I'll circle back to the any willing provider piece, is delinking PBM compensation from drug prices. And we're also starting to see this type of legislation come down in states, particularly Colorado and California have recently passed laws that require delinking. And what that means effectively is that what at least the Consolidated Appropriations Act has said is that it prohibits PBMs in Medicare Part D from earning compensation that's directly tied to the list price of drugs, rebate amounts that the PBMs may be receiving for putting drugs on their formularies, or other sort of volume-based fees or remuneration that they're receiving. When I say they, the PBMs are receiving, and effectively, I think how we're going to see this delinking requirement impacting PBMs is that I think they're going to move towards more quote unquote bona fide flat fee arrangements with their plan sponsors, with drug manufacturers. And I think the goal behind this type of legislation and the provision specifically within the Act was to eliminate incentives to favor high-cost drugs with larger reimbursements. And the way, from our perspective, that benefits specialty pharmacies is by eliminating PBM incentives to favor higher-cost drugs. From our perspective, we're hopeful that it's going to reduce spread pricing, meaning the amount that the PBMs charge to the health plans versus the amount that they reimburse pharmacies, in hopes that they will increase reimbursement to pharmacies on a going forward basis. But it also, we think, will work to eliminate incentives for patient steering that the PBMs currently have, where, as Jonathan mentioned, oftentimes they are steering patients to their own affiliated pharmacies, their own affiliated specialty pharmacies, because by delinking that specific compensation to drug prices, moving PBMs away from, like we said, incentives to favor higher cost drugs, hopefully that levels the playing field and it allows additional access by the non-affiliated specialty pharmacies to service patients where PBMs are not saying, well, if we send that $20,000 prescription to our own pharmacy, we're going to be able to obtain a significantly higher amount than we otherwise would. The goal here with this provision is really to level the playing field across the board. And we're hopeful we're going to really see that operational impact on pharmacies, especially specialty pharmacies that are obviously unaffiliated with the PBMs. I think another provision that is going to have a big impact on the PBM industry as well as pharmacies are the enhanced transparency and reporting requirements that are mandated by the Act. And that the Act imposes what I would say are extensive reporting obligations on PBMs because they're, in certain instances, going to be required to provide semi-annual reporting or at least annual disclosures to the federal government and, particularly to CMS, that deal with rebate amounts that they're receiving from drug manufacturers or plan sponsors, the spread pricing charges that they're engaged in, pharmacy reimbursement methodologies, clawbacks and fees that they're, taking from or charging to pharmacies, affiliated pharmacy arrangements like we've talked about, and really compensation, received from manufacturers as well. And I think, CMS having access to these substantial reportings and this data, they're going to be able on a going forward basis to use the data for future rulemaking to the extent that I think that this data is revealing, an uneven playing field that that Congress, by enacting this law, is really hoping to make much more even. And I think the third provision, as I had indicated, that really is going to be most important to independent, or let me say, non-affiliated pharmacies really are the network access and any willing provider provisions and the implications therein by the Act, which ultimately will strengthen pharmacy access protections by increasing scrutiny by the government on PBMs of patient steering, affiliated pharmacy favoritism, which, as I just talked about, we're constantly seeing a lot, and that's one of the areas that non-affiliated specialty pharmacies are really being impacted by. Also, I think this is going to address reimbursement disparities that Jonathan had talked about. And really, we're hopeful that, these reforms on the anti-willing provider side will act to curb restrictive network practices and allow pharmacies who have an interest in participating in PBM networks to be able to do so. And really, the Act, what it does is it increases the regulatory focus on the pharmacy network equity. And really what the provisions of the Act are doing is not necessarily federalizing, stronger protections under the anti-willing provider law, but they are providing the opportunities for CMS to work through additional regulatory rulemaking processes and really define what should be considered reasonable and relevant when we're talking about contracts that are offered to pharmacies under the anti-willing provider provisions, et cetera. So let me stop there and see what other questions you may have, Sheila, and we can certainly continue the discussion on anti-willing provider law, what CMS is going to do on a going forward basis, and how that's going to impact independent pharmacies as well as the PBM industry.
Do you agree, Brad? Like, a lot of these provisions are helpful, right? But only if they're enforced, like the reporting requirements.
Well, you're absolutely right about that, Sheila, and that's a huge issue that, and I think Jonathan will say the exact same thing, that we see on a daily basis. Regardless of how good the reform is, regardless of how many strong laws there are on the books, to the extent that there is no entity or to enforce those laws, or enforcement mechanisms are not acted upon, you're right. I mean, that has an impact to diminish the bite, if you will, of those laws that have been passed. So we absolutely need, those we also absolutely need those enforcement mechanisms. One nice thing about the law is the increased federal enforcement authority. When I say the law, the increased federal enforcement authority that has been mandated under the Act. So the Act authorizes stronger oversight of all the provisions that are discussed herein, mandated therein, as well as ongoing or existing regulatory issues, existing laws, et cetera, by, CMS, the Department of Labor, when it touches on ERISA-related issues, HHS, which might have a larger authority and preview, obviously, of CMS as well as FDA, et cetera. And then also the Treasury Department. The law, the Act, indicates that civil monetary penalties would be applied for inaccurate reporting or non-compliance by PBMs. And some of those penalties can reach up to $10,000 a day for certain violations of the Act. So, just to bring that home, I think enforcement.
And Brad, can I just jump in and just add one more government agency to the mix? I mentioned, Sheila, the FTC and the fact that since 2022, they've been involved in a 6B study of PBMs. The FTC has jurisdiction over any company in any industry that is involved in unfair trade practices. And what is, I would say, a pretty reasonable conclusion based upon the approximate 140 pages of findings that the FTC has already issued with regard to certain PBMs is that they have concluded that PBMs have engaged in unfair trade practices, that certain acts, at least as of the date those reports were issued, constitute unfair trade practices. We are anticipating that the FTC will be issuing a final report, hopefully by the end of this year. We don't believe that the change in the administration since the study commenced is going to impact either the pace in which they will conclude the investigation or the findings that have already been reached. And we expect that the final report will be pretty much a recap of what they previously found in the interim report. So the FTC will also have enforcement authority to go after anyone in the industry that they believe is involved in unfair trade practices. So in addition to CMS, HHS, the Treasury Department, we expect that the FTC is going to be particularly active with enforcement actions. And what is particularly notable for us as pharmacy attorneys is in between the first and second report, the FTC, without any forewarning or notice, issued a report that it had determined that as an agency, it was not being aggressive enough in enforcing what it deems to be unfair trade practices and reining them in. So if you look at the dates of the interim report, the date in which that notice was issued by the FTC, and then the second report, I think it's fair to assume that that report was largely influenced by what the FTC was concluding with regard to certain players in the PBM industry, that the notice that the FTC has a responsibility to be more aggressive, formally bringing complaints against companies that they believe are involved in unfair trade practices from here on out should be much more of an expectation. So while CMS, HHS are certainly going to be paying attention to the way in which PBMs are or are not complying with the act, we expect that the FTC is also going to be a major player. And if the conduct at issue is serious enough, the DOJ formed a couple of years ago a healthcare task force, the purpose of which is to investigate, among others, PBMs that they believe may be involved in certain anti-competitive behavior. And we expect that as the act moves forward and its provisions are much more clearly defined, that coupled with a final report by the FTC will also likewise cause the DOJ to move forward with certain enforcement activities. So there's multiple sources that now have the legal authority to enforce any violations of either the act itself or what I would say are existing laws that prohibit unfair trade practices or certain anti-competitive behavior.
All right, so what is the current status of the act?
So, Sheila, as you may be aware, and your listeners may be aware, the act passed in February of this year. Not all provisions, though, went into effect immediately. And I can talk about that briefly because there are still some issues I would say are quote unquote in flux. And what I mean by that is, over the next couple of years, there are requirements in which the government, particularly CMS, has to begin rulemaking and guidance development. And that's with regard specifically to reasonable and relevant standards, number one. And as Jonathan had mentioned, part of the regulatory scheme under the federal any willing provider law by Medicare Part D is that contractual terms and conditions need to be quote unquote reasonable and relevant. They have to have reasonable and relevant standards for pharmacies to participate in those PBM and Part D sponsored networks. So over the next year or so, we're going to see that CMS is going to publish a notice of proposed rulemaking to define those reasonable and relevant terms. I think we're going to see a lot of input from pharmacy stakeholders as well as other, PBM industry stakeholders indicating what terms contractually, that govern the relationships between PBMs and pharmacies. What those standards should be, what those pharmacy participation requirements should look like, what network access protections should be included in those standards, and, potentially applicable, what reporting obligations by the PBMs and transparency and disclosure may be required to be provided to be provided by PBMs to pharmacies on a going forward basis.
And Brad, can I just jump in on one thing there?
Yeah, please, John.
On this particular point, one thing I want to make sure that your listeners are aware of is the fact that they now have the opportunity, assuming that they own and operate a pharmacy, to work with CMS to help to define what constitutes reasonable and relevant terms of network participation. While we have always found CMS to be a pretty welcoming government agency in terms of fielding concerns by independent pharmacies, at this point in time, they're making clear that their doors are as open as ever to field not just complaints, but assistance and helping them define what should ultimately be determined to be a fair, reasonable, and appropriate set of terms and conditions for network participation. So most of the major pharmacy associations are already communicating with CMS. We know that a number of independent pharmacies have already reached out to CMS and are working with CMS to provide it feedback on what they believe would constitute fair and reasonable terms for the act. One thing that is important is that there is a deadline for associations or pharmacies to convey that information to CMS. The deadline for any comments or other feedback to be provided is in April of 2027. So to the extent that any of your listeners would like the opportunity to connect with CMS and share their thoughts on what would constitute reasonable and relevant terms of network participation for a pharmacy of their type, getting that in motion now really could be quite important. The biggest issue that I think pharmacies want to share with CMS is what is reasonable with regard to reimbursement. That is another area where I think states are ahead of the curve, which have been often much more specific than the federal government has up until now. So far too often, the agreements that are provided to pharmacies by certain PBMs, the reimbursement rates are non-negotiable, and often those reimbursement rates are going to be below the wholesale costs that independent pharmacies incur in purchasing medication. So where the starting point is reimbursement below wholesale costs and all the administrative services that have to be provided by particularly specialty pharmacies in delivering those medications, making sure that their customers are being properly cared for, are not reimbursed. I mean, it really, really becomes difficult for pharmacies to remain in operation if their wholesale costs are not covered, and hopefully they're getting something a little bit above that, which allows them to offset the administrative costs. So what would constitute reasonable reimbursement is now on the table. What would constitute a reasonable dispensing fee is now on the table. The extent to which certain services attendant to the provision of medication is on the table. So for independent pharmacies who have been looking for an opportunity to improve their financial circumstances, the next year really is the best opportunity up until now they will ever had to do that.
Yeah, and I agree completely with Jonathan and what you're just saying, John. And I think I just wanted to add the point that CMS's directive to define what terms are, quote, reasonable and relevant to participation in a Part D network is extremely important. To your point, John, I think PBMs historically have argued that pharmacies, technically under the enabling provider law, could, always join their networks, but they impose contractual conditions that make it, most typically economically or otherwise, sometimes operationally impossible for the pharmacy to, either participate accurately in the network, to be profitable in the network, or even to join a network where reimbursement rates are so low, that they're not going to be able to continue operations to the extent that, they're reimbursed below wholesale costs. And to sort of just to pick up on the last point about April 1st, 2027, that John mentioned being the deadline, once all those comments are in, around that time in the spring of next year, HHS or CMS rather is then going to be required to issue a request for information to analyze trends in PBM participation, contract terms, et cetera. And then that's going to be another opportunity for stakeholders to be able to specifically comment to CMS. So obviously, I think when that time comes, Sheila, certainly your members and other pharmacy stakeholders are definitely going to want to get in and provide comments, and I'm sure we're going to be seeing a huge influx of those. And then 2 years from now, a year after that, in about April 2028, CMS is then required, at least under the Act, to establish their final standards for what are going to be reasonable and relevant contract terms, which will then ultimately go into effect January 1st of 2029.
So do you foresee any challenges to the Act, and what do those look like?
I think we certainly do. And one of the things that we typically see are challenges to any, I guess, subversion of the status quo, whether they're from pharmacy benefit managers, pharmacy benefit manager associations, PCMA, other stakeholders, et cetera. We think anything that, might impact their bottom line is very likely to be challenged by the courts. I can't tell you sitting here right now that, that's going to be particularly successful. You may be aware, and Jonathan, if you want to opine on this, I think you have some very good insight into this, that very recently there were a number of stakeholders that challenged the IRA, the Inflation Reduction Act negotiation requirements, that CMS is engaged in. And very recently, the Supreme Court shot down writs for cert, meaning, petitions that those entities have filed to get the Supreme Court to hear their case as to why that law is problematic, why they don't think that the law is constitutional, et cetera. So I certainly do think we're going to be seeing constitutional challenges, pushing on CMS's authority, arguments that they don't have the authority to implement certain of the rulemaking that they're being directed to, that they don't have the authority to define reasonable and relevant terms because those should be subject to private negotiation. But I do think, that constitutional line and the challenge to the rulemaking authority is where we're going to see challenges coming to this act.
So just, I guess, add a couple of extra points. So yeah, what Brad's referring to is, as of today, a very recent decision by the U.S. Supreme Court on May 18th, 2026, not to allow cert, which means it refused to hear an appeal from certain drug manufacturers who were challenging the legality of the Inflation Reduction Act. And I would say that the U.S. Supreme Court's refusal to consider that kind of in line with the circumstances in which over the past few years it has refused to hear other petitions for cert, other appeals that touch upon what would constitute fair and reasonable terms for network participation, failed to touch upon the issues between PBMs and pharmacies with regard to what constitutes appropriate reimbursement. Most of your listeners might be familiar with the Rutledge matter, where Arkansas passed a law as to a minimum amount of reimbursement that pharmacies in that state were to receive when they filled medications. The lobbying group that Brad referred to, PCMA, challenged the legality of that law, claimed that that law was implicating ERISA, and because it was implicating ERISA, a state did not have the ability to pass that law. In that case, the U.S. Supreme Court accepted cert. It agreed to hear the appeal, and it determined that Arkansas's efforts to address a minimum amount of reimbursement did not implicate ERISA, and therefore it was lawful. I think, and again, we can never predict what the U.S. Supreme Court may or may not do. I agree with Brad that we're likely to see challenges to the act. I am fairly optimistic, based upon the current state of the case law, that those challenges are not going to be successful. Now, there are going to be some other laws that are being passed on a state level that I think are going to be in the courts over the next couple of years. So, for example, states that are really going out of their way to protect independent pharmacies have recently passed laws prohibiting certain PBMs from owning or operating a pharmacy in their state. That was first done in Arkansas, immediately challenged by PCMA, and the courts issued an injunction preventing the state from implementing that law, which would have essentially caused the closure of any brick and mortar pharmacies located in the state that are affiliated with PBMs, would have prohibited PBMs from even mailing medications into the state. I think that the states that have passed similar laws that are being challenged by PBMs and their lobbying groups, I think those cases are going to move through the court system. I think they give rise to some interesting constitutional questions, but however those cases play out is not going to impact the provisions of the act. Those provisions, first of all, are on the state level, and the provisions contained therein really don't overlap with the types of cases we anticipate seeing, like the case in Arkansas, over the next couple of years.
So this is only the beginning, right? Much more to come.
Much more to come, but for most pharmacies, which have for many years really pled with the federal government to provide them some protection with regard to their bills for Medicare beneficiaries, individuals who are participating in ERISA insurance plans.
Mm-hmm.
We are on the brink of what will be the most significant reform they or PBMs have experienced since the inception of PBMs. And for pharmacies that for decades were expressing concern about their ability to get into networks, stay in networks, be reimbursed fairly, that this really marks the best opportunity that we and they have ever seen that can finally deliver to them the kind of reform they've desperately been seeking. So we're hopeful that by 2029, the schedule that's in place will remain in place. And by 2029, the act will be law. It will be enforceable. The way in which reasonable and relevant will be defined in a way that is fair and appropriate for both PBMs and pharmacies. And pharmacies will be able to service their customers without the constant worry as to whether or not doing so as they believe is necessary from a financial standpoint is unfeasible.
Well, thank you so much, Jonathan and Brad, for chatting with me and for breaking down, right, the 2026 Consolidated Appropriations Act. There's a lot in here to digest.
Well, thank you very much, Sheila.
Yeah, thank you, Sheila. This is our pleasure today.
As a reminder, NASP corporate members are invited to be my guest on one complimentary podcast per year. For more information about this or other NASP membership benefits and events, please feel free to reach out to membership@naspnet.org or visit our website at www.naspnet.org. Until next time, have a great day.